Your Lordship, the new provision, which is section 187, has been a little bit modified in the present law. It states that the police custody, the omission, there is an omission of the police custody only thing. And now, this he was remanded for a period of 90 days entirely in the custody. Whereas, the counsel will be dealing in detail that the legal limit for the detention period is only 60 days in the cases of where the investigation procedure is 90 days. Your Lordship, this will be dealt in detail by my co-counsel. Much obliged, Your Lordship. It can be clearly seen that the remand proceeding in the matter in hand was in contradiction to the requisites enumerated under the provision. Moving forward to the last part of my second limb, that the conviction of the appellant under section 375 read with section 376 of the JPC was inadequate. In the of FIR law the prosecutrix, following which the police arrested Jamie and was subsequently tortured by the police officer to confess to the alleged offence instead of investigating whether the accused is innocent or not. Even in the absence of the appellant, he was sentenced to a life imprisonment for a crime he did not commit. Your Lordship, the statement that the crime he did not commit will be substantiated by my co-counsel in the subsequent issues.
From where you have inferred that he has been tortured in the custody?
Your Lordship, it has been clearly enumerated in the fact sheet. Your Lordship, in the fact number 22, the last 3 lines, during this period he was tortured and coerced by the police to confess to the alleged offence on multiple occasions. If Your Lordship is satisfied, may I proceed? Much obliged, Your Lordship. As submitted, this shows that there was an inadequate application of the judiciary in the present instance, thereby giving an adequate ground for the appeal to be maintainable. May I direct Your Lordship's attention to the case of Majal versus State of Haryana in flag number 3 given complaint. It is necessary for the High Court to consider whether the trial court's assessment of the evidence and its opinion that the appellant must be convicted deserve to be confirmed. This exercise is necessary because the personal liberty of an accused is curtailed because of the conviction. Concluding that in light of above submissions, it is clear that there was no adherence to the provisions and principles of the procedural laws, and the conviction was based on loose grounds rather than absolute evidence in the present instance. Thus, the present appeal is maintainable in the Honorable High Court of Advocacy. If Your Lordships have no substantial questions on the issue, I would like to proceed with issue 2. Much obliged, Your Lordship. Issue 2. Whether the trial and absentia adhere to the provision and principles of due process. It is most humbly submitted in this honorable court that the trial in absentia did not adhere to the principles of due process. The principle of due process is to safeguard individuals from arbitrary unfair treatment from the state. This ensures a reasonable and just trial and something that is fanciful, oppressive or arbitrary. This is guaranteed under Article 21 of the Constitution, and it has been mentioned and enumerated by the Honorable celebrated case of Maneka Gandhi versus Your Lordship, to show that there was no reasonableness in the trial
that this is the first date and the law requires this is the minimum time frame required, and before that the second warrant is issued. Okay?
Okay.
Okay.
Your Lordship, the first date that is mentioned in the fact sheet is 1st January. It is mentioned that they tried to execute the warrant. Nowhere it is mentioned that when was the warrant actually issued. It can also be construed that it was issued on the same day itself. It can also be construed that it was issued beforehand. Whereas the time limit is given of minimum 30 days to declare him as a proclaimed offender. The second warrant, which is the consecutive warrant.
One thing you just try and understand.
Indeed.
Here it says, however, when the police attempted to execute the warrant on 1st January, so the warrant of arrest must have been issued on an earlier date. Now, second warrant is getting issued on 28th January. So how do you infer that there was no 30 days within the date of issuance of first warrant and second warrant? If we say that first warrant was issued in 2nd December or 5th December, then obviously 30 days time is given, and after 30 days the second warrant has been issued. See, I'll tell you. You need to formulate and then slowly explain. Don't try to memorize things and just go on saying. So this
That is what we are containing, Your Lordships. Much obliged, Your Lordship. May I proceed? Yes. Much obliged. Your Lordship, this 30 days period is what was in the compulsion of section 84. We submit to the part that he was declared as a proclaimed offender after following the requisite procedure. But Your Lordship, the committal of the case happened in April 2025, which means that the present case, Your Lordships, is solely trialable by the sessions judge. And in cases where the case is solely trialable by the sessions judge, the framing of charges is done by the sessions judge himself. Your Lordship, it is mentioned in the proviso of section 356 clause 1 that there must be a 90 days lapse from the date of framing the charges. Your Lordship, if we add on the 30 days and the 90 days total time period, it sums up to a 120 days. But Your Lordship, in the present instance, the cognizance was taken in the end of December, and the committal was in April 2025. So Your Lordships, it can be clearly seen that there is a passing of merely somewhere around 90 to 100 days. Should have been adhered to, and the trial court should make sure that these were complied with. But Your Lordship, in the present instance, that has not happened. Your Lordship, this concludes two of my contention, that there was no adequate notice given, and that the trial court did not comply to the mandates of the given provisional.
Notice not given for trial.
Indeed, Your Lordship.
But then there is a legislative provision which talks about trial in absentia, meaning whereby there is a legislative approval of trial without notice. So why the court shall not assume that legislative intent has been complied with by the prosecution, and thus the process is entirely legal?
Your Lordship has raised a very pertinent question, but Your Lordship, even before commencing with the trial in absentia, the court has to make sure there are certain conditions under subsection 2 of 356, which is the provision for trial in absentia, which state that the court shall ensure that the following procedure has been complied with before proceeding under subsection 1. Your Lordship, the conditions are...
Can you please satisfy the court on this point that
Yes, Your Lordship. Because...
that's all?
Thank you, Your Lordship. Your Lordship, moving to the third contention, that the opportunity to be heard of the accused person was not safeguarded, Your Lordship. Your Lordship, for a meaningful realization, as I already submitted, for a meaningful realization for a right to defense and to ensure the right to be heard, the accused's presence becomes vital. The presence here can refer to both physical and mental presence, or either of them. Your Lordship, when a lawyer is representing, it is usually only the mental presence of the accused and not the physical presence when the accused is absent. And in the absence of an accused, Your Lordship, a lawyer, as we stand here, we cannot exactly adequately define as to what were the facts and circumstances from his side, which means that the lawyer will not be able to properly present it in front of the court as to what
It was his lawyer, no? He
No,
has
Your-
appointed.
no, Your
Or it's a
Lordship.
court's lawyer.
It was the court's lawyer, Your Lordship, because he was absconding. It is the duty of the court to appoint a legal
Right.
representation at the expense of state.
Right.
Much either physically or as there was no adequate notice as already submitted, the physical presence was not complied with, and the mental presence of the lawyer, because there was an inadequate representation, thus denied him the right to be heard, which defies the principle of ordi alternum partem, which means the right to be heard or let the other side be heard as well. Your Lordship, moving to the last contention of my second argument, that the orderly procedure. Your Lordship, proviso of section 356 clause 1 says that the trial in absentia shall only commence after a lapse of 90 days, as already stated, and also the procedural mandates under section 187 clause 4. They have not been adhered to, thus showing that in the present instance, the orderly procedures were not complied with. Your Lordship, this concludes that the trial in absentia has not adhered to the
the present case. Also, my lord, moving further, the remand was granted in a mechanical manner in the present case, as it was an unlawful detention of the accused and the inadequate application of judicial mind, and not following the procedural mandates of section 187 subsection 2 of JMSS, which clearly states that if the offence is a punishment of more than 10 years, then the investigation period is of 90 days, and out of 90 days, only 60 days he can be detained. But here he was detained for the 90 days full. The investigation period here correlates with the remand period by the state missionaries, and he was not being granted bail within that period. He was granted default bail after the lapse of that period, which is again an unlawful detention and affecting his freedom of free liberty. Under Article 24. Moving further, that is the application of substantive laws by the lower court was not appropriate. My lord, first of all, there is a consensual sexual intercourse between the accused and the prosecutor, as it can be clearly constituted from the fact number 17 of the Moot proposition. And the prosecutrix here consents to the act, evaluating various alternative consequences, and being a mature woman, she very well knows the consequence of her consent, and then also she consents, and it cannot be made out afterwards that it has amounts to rape on false pretext of marriage. This was absolute consent by the prosecutrix, as absolute consent. She voluntarily consented. It was not under any pretext, as both of them at that time of the consent were willing to marry each other. So afterwards she cannot use that same. Indeed, the lordship, that's the point. Indeed, lordship, but afterwards the same consent, she stated that it was a false pretext of marriage, but it cannot be do so. But at the time of consent, she knew the consequences of her consent, and we voluntarily agreed. But she used the same line afterwards. No, your lordship, that is not the concept, but she was aware of the consequence of her act, that if I am consenting. She was aware that if I am consenting. No, your lordship, she was aware that if I am consenting to a man whom he trusted, that he will marry him further. But she was not sure the man didn't marry him due to the suspicious nature of his own, of her own.
कनेक्टेड है वो नहीं नहीं है
Indeed, your lordship, and the accused from the very intention had clear intention to marry her. Accused from the inception had married her. Then, but afterwards she used the same line that the accused has made a promise from the very inception on the false pretext of marriage. But it can be clearly constituted from the fact number 5, 10 and 11 that accused from the very inception had a clear intention to marry her. He had never shown any intention not to marry her or of his lust nature, but he clearly intended to marry her. But afterwards, due to the suspicious nature and various acts done by the prosecutrix, the accused was forced to breach the promise. But there is a clear-cut distinction between the breach of promise and the false promise to marry, which is again stated famous in the case of Pramod Suryavan Pawar versus State of Maharashtra. My lord, may refer to Pardon, lordship. Indeed, your lordship, but the accused who had not committed the offence for which he was charged and convicted. The charge was wrongly framed on that, then the conviction was wrongfully based on the false charge sheet, and that cannot be considered in a criminal case. Indeed, your lordship, I will be dealing that further in my constitution. Indeed, lordship, my lord may refer to paragraph number 7 of the given complaint. Compendium, in which the Pramod Suryavan Pawar versus State of Maharashtra, the lordship famously stated that the court has repeatedly held.
वीडियो चलेगा तो बताना एक मिनट मेरी इमेज कहाँ गया अरे फटाफट में ना
involves an active understanding of the circumstances, actions and consequence of the proposed act. An individual who makes a reasoned choice to act after evaluating various alternative actions or inaction, as well as various possible consequences. On 20th November 2023, Jamie saw Oliver talking to one of their startup founders. So, on the very first time,
this occasion itself, there was an occasion for the lady, Jennifer, to raise a doubt against the husband. Proposed marriage. I'm not that one.
My lord, here Jamie is the accused, but
Jamie is the accused and
Oliver is the
lady.
lady.
Proceed. So lady and male. So female raised a doubt against the male.
After weighing the case, but here, my lord, in fact number 9, Oliver had talked to the startup founders, and Jamie had saw first time Oliver talking to the startup founders.
So prior to this, point number 10, prior to that, there was doubt created in the mind of lady.
In the mind of Jamie, my lord, here the prior to that.
And why I cannot say 9, 10 and 11 we don't rightly say. If we go by para 11, let us read it. However, in May 2024, Oliver began to notice changes in Jamie's behavior.
Indeed, my lord.
It says he grew distant, avoiding any discussion about marriage, and thereafter he agrees to marry someone else also. He is a family member. So Jamie knew that he is not going to marry her, and after knowing it fully well, that he is not going to marry, he agreed with his family member that yes, I can marry someone else. After that day, is he not deliberately cheating or how?
This is a very important question, my lord. I will be answering it to the process. As my lord stated in fact number 11, it's clearly written, Oliver began to notice some changes in Jamie's behavior. I completely agree with this. But in the same fact, my lord, in the last day, despite her repeated influence, Jamie reassured Oliver that he was committed to their future together, and but was reluctant to finalize any plans for the wedding. My lord, if the postponement of the plan for wedding cannot be considered as he didn't willing to marry her, he immediately reassured.
No. Again, this paragraph says clearly that he had determined himself that he is not going to marry, but he is still assuring her that yes, I will marry you. And after that, you see, he agrees. So what you have to say about it?
Yes, my
He
lord.
is not going after this date.
Yes, my lord.
He is not going to marry her.
My lord, if you were referred to from fact number 5 to fact number 11, in no other instances, Oliver.
Let us come to that.
Yes, in fact number 5, Jamie first time expressed his intention to marry Oliver, but
But
in
you
the
can
fact
turn
sheet,
your
nowhere
camera
Oliver
internet का phone
Oliver
change कर
anywhere
लेना
never expressed her
नहीं
intention.
Over the next few months,
Indeed, Lord.
the two developed
पर सबसे पहले अपना फोन फिर स्टार्ट करो
with Jamie Express.
हाँ ज़्यादा दिमाग मत लगाओ
Environment whether on the first day, because this thing promised to marry. There are controversial judgments, we are attached to that thing is prior to the occurrence. If a promise has been made, then it will come under the section.
Indeed, Lord. But the close
The word
relationship.
is develop close relationship in few months. So it is not clear from the fact.
My lord, in the
I
fact number
argue that the prosecution has failed to bring this fact.
Indeed,
Because
Lord.
on the very first day, it was a proposal for marriage, and then occurrence of 376.
Indeed, Lord. I was just saying that. In fact number 10, they developed a physical sexual relationship, but before that there was no such kind of relationship. And Jamie in fact number 5 also, and again in fact number 10, he proposed they have to marry. After that, with her consent, they developed a sexual relationship, and she voluntarily consented. But afterwards, the first charge was same on the first certificate of marriage, which is completely false.
Please develop this further. If you just read the incidents after para 11
Indeed, Lord.
and up to 18, 18 says what? By the end of August 2024, Jamie had completely severed all personal contact. Okay? So here he has severed all contacts and he has agreed to marry somebody else. After para 11, the incidents which are taking place, including this para 17, knowing fully well that after para 11, at least it was clear to the appellant for whom you are appearing. Para 11, he was firm, that he is not going to marry her. He has withdrawn the money also from the bank, and then he still goes on 10th of July 2024. So whether this period, which is after, May 2024, for doing the same thing after May 2024, whether he will not be under a trap under the new law for an offence committed by him deliberately after May 2024, when he was knowing that he was not going to marry her.
Immediate process. As this is a continuous process, and the process continues from the December itself until, as Remand stated, till July 2024. And the first thing I would like to clarify that when he was used to marry someone, Alexa, that is first of all due to parental pressure and due to the suspicious nature of Oliver and the prosecutrix. That is, she viral the videos, she used to record the videos and photos discreetly, which is the breach of confidentiality and privacy, which I will be dealing in further issue number 4. Due to these reasons, JB was forced.
Where is the breach of confidentiality when everything was done on the basis of trust?
In the in fact number 20,
You want to build an argument as per your convenience without looking at the kind of trust imposed by the other partner.
My lord, the Oliver in fact number 20 had posted the intimate pictures and videos across social media and making them accessible to the public.
That is much answer.
Indeed, lordship. But here, due to these all reasons, he was forced to think twice that he is she the right partner or not. And this suspicious nature of her makes him to think. Or the JNS, as this is a series of events and the continuous event, and the last cause of action, that is in August 2024. Before August 2024, both were not sure and ambiguous that the relationship is still remaining or is completely severed out. Only in August 2024, that is end of August 2024, after JNS has come into force, Oliver came to know finally the end of relationship. So as the initial charge sheet was framed under JNS 69, afterwards, knowing fully they dragged it to the 375 JPC, even if the last cause of action being August 2024. This is again complete a violation of procedural mandates and the procedural aspect. With this, I would like to move to a further issue number 4 about the offence. Much obliged. In issue number 4, whether any offence in the instant case has been committed, if so under which laws. It's most humbly submitted before this honorable court that indeed an offence has been committed. But the offence has been committed on the majorly on the part of the respondent prosecutrix and not on the behalf of appellant. But this was completely ignored by the state machineries during the investigation process, the reason for which they extended the remand for investigation. They focused only on torturing the accused and forcing him to confess the alleged offence. Being the state machinery, they completely knew the confession to the police officer is not valid confession under evidence.
Relationship between Oliver, does he have a case that he did not have any sexual relationship with her? What confession your client is going to be doing?
No confession has been made, but I only want to state that state machinery, knowing this all, is trying to torture and trying to make confession instead of focusing on the investigation.
Why can it torture you? It is the open fact. It is the open fact that your client was knowing Oliver and Oliver under a belief that you may marry her, she left her job, she started doing with you, then you started depositing amount in her account, you are allowing her to withdraw, and then you are allowing her to have a relationship with you, you are interposing.
स्क्रीन पूरा बंद करो, बिना चार्ज में लगाओगे मैं स्विच ऑफ नहीं किया, स्क्रीन बंद करो और फिर ऑन करो और कॉस्ट को ना बगल में उसको खड़ा रखो, बार बार चार्ज से मत निकालो.
With your family to marry someone else, and finally you go on vacations and again do the same thing, and still you say that police is torturing you. What police will do? You are not going to confess anything. Everything is open and it is a clear thing. By your suggestion, not the law of the record. Just to argue, you are not arguing. The pertinent issue which you are supposed to focus come, you should argue. Otherwise, what will happen? You have a limited time frame to argue a case, and irrelevant things will also take time. According to me, this is the most irrelevant thing you are touching. You confine to issue number 4. Now, rest.
Fact number 5. It is expressly mentioned that Oliver has also contributed a substantial share to the deposit. He never forced the prosecutor to submit or to deposit anything. She voluntarily contributed. And also the house which was owned, which was sold afterwards, they also brought the house on a loan together. He never forced her to brought a house.
So your client has sold that house without her consent?
That was in his name only. So
His name, but you yourself saying that she had also contributed.
no, my lord, they have not contributed.
No, Oliver did not contribute.
She agreed that house would be in Jamie's name.
No, you just now said
Both of them.
that both of them.
Bought. If both of them bought in a close relationship, she must have content.
So where from you can suggest us that it was not a contribution of Oliver? You just show it.
My lord, if may refer to fact number 5 and 8.
5 and 8, yes.
In 5 it's clearly written, Jamie also started saving a substantial sum of money by depositing it in fixed deposits in the bank branch where Oliver previously worked, stating to her that he would be using it for the marriage. But for the marriage, he never stated for whose marriage. Will he marry her?
Additionally, Oliver has also contributed a substantial share to the deposit.
That is the
It is very clear.
Yes.
Eventually, they bought a house on a loan in Jamie's
Jamie's name.
So it is bought in Jamie's name,
Indeed,
but
Machinery should have pointed out this in the trial itself, but they didn't do so. They only focused on the false rape charge and false notice of marriage.
so this is the correct argument. You have to say what a charge it is.
Indeed, this is not a charge. Indeed,
So there are plethora of facts. You are not supposed to argue everything. Yes.
The charge itself should be.
as this is matter of an appeal case, only we should focus on the trial, conviction, and the remand case.
Correct.
My lord, probably would like to move further. As I would like to move to the further issue, as this is clear, and I want to make clear the IT Act and the offences did by her. And as this is not the case, we should like to move to the further issue, that is whether the repeated authorization of police remand by the lower court till 14 December was in accordance with the provisions of criminal procedure and the principles enshrined under the Constitution of Jharkhand. It is most humbly submitted that in the Honorable High Court, that the repeated authorization of police remand till 14 December was done in a cyclic manner, as it can be clearly constituted from fact number 21, fact number 23. It may refer to the Moot proposition. The remand was extended till 14 December in a cyclic manner. In a cyclic manner, I don't suggest it is done in a mechanical manner without application of adequate judicial mind. Indeed.
Are you supposed to argue out on these issues?
Indeed.
On the basis of the issues which were or you propose it?
Issues was already have been given and also body given already. Indeed. As the remand authorization was not in accordance with the provision of 187 of JNS, as I already stated, the investigation period is of 90 days and the maximum remand stated in 187 subsection 2 of JNS is 60 days. But here he was fully detained for the 90 days period and not for the 60 days period. And the extra custody was the police custody and not the judicial custody, my lord. And the extra 30 days of police custody clearly violates the provision and also the articles of the Constitution. As the undue remand proceeding and the false rape charge violates Article 21 of the Constitution. If my lord may refer to Indeed, Lordship, I am just stating that this all due to this remand proceeding, the right to speedy trial in the other Article 21 has been violated, and also due to the false rape charges, the right to live with dignity is also been hampered under Article 21 of the Act. Indeed, Lordship. Indeed, Your Lordship, in the famous case of the Motilal Saraf versus State of Jammu Kashmir, if you might not refer to flag number 9, it clearly stated trial procedure continues right from the investigation period, and trial is a consequence of the investigation. Without proper investigation and proper evidence can be recorded, the trial has no value if the evidence and the investigation are done in a proper manner. And if remand is unnecessarily being extended without any reason, and if the reason being stated is for investigation and is not used for investigation, then unnecessary delay in the trial. Suppose the trial is to happen today, due to the unnecessary 90 days demand, the trial is postponed beyond 90 days. So again, right to speedy trial is violated. In the famous case of stated in Surana as I have already stated, he was also coerced to violate Article 23 also. With this, I would like to submit that this repeated authorization of remand and also the violation of many of the fundamental rights is clearly against the procedural mandates given of human personality has been mentioned. That is the violation of naked violation of human dignity. If a person has not committed anything and will charge falsely. Therefore, in light of above submission, it is clearly seen that the repeated remand authorization by the lower court violates the provision of the principles enshrined under the criminal procedure, standing in contravention to the constitutional principles. My Lord, I would also like to make clear the point my co-counsel also raised. That is the committal of the case to the trial court. That is, the case was committed to the trial court in April itself. And if my Lord may refer to the 356 provision, it clearly states if a case is committed to the trial court in April, then charge must have been framed in April itself. But the trial was commenced and the trial was concluded in April itself. If in the same month itself the trial has been case has been committed and trial has been concluded, it clearly violates the 90 days provision. 90 days has no way forward. As this is the present case in appeal, is in May. We are standing here in May. And the trial completed was successful in April and commenced in April. So only within 30 days one has been done. So within 30 days, how the 30 days notice has been proposed, how 90 days time has been given, is all remain down.
So you mean to say there is no opportunity given?
No opportunity. As
And the trial court or before that, the police must have
there is a lack of
so that you would have appeared or you would have taken a defense.
Indeed, Your Lordship. But all these procedural lapse clearly indicates that there is a lacuna in both in behalf of the ensuring the procedures by the trial court and also the duty of the state machinery. And with this, it cannot be said that he has voluntarily waived of his rights. He has not been provided enough opportunity, enough time as per the provisions.
Yes.
Indeed, Lordship. With this, I would like to continue with the prayer. Wherefore, in the light of issues raised, argument advanced and authorities cited, it is humbly requested that His Honourable High Court may be pleased to adjudge and declare the present appeal is maintainable in the Honourable High Court. The trial in absentia did not adhere to the principles and provisions of due process, and the conviction is liable to be overruled. And the lower court application of both substantive and procedural laws was incorrect, and the offence in the present case was committed by the respondent and was completely ignored on the part of state machinery. And the repeated authorization of remand by the lower court is not accordance with the provisions of criminal procedure and principles enshrined under the Constitution. And hereby, my Lord may pass any such order or direction as the court deems fit, proper, for the appellant shall duty bound free. This is all
What
right.
any other order you are asking? You are officer of the court. You advise this court. Suggest this.
In parliament,
You said any other order.
Indeed, Lordship.
Can you just guide this court that what should be that nature of order?
What you understand with any other,
Any other order.
Any other, Indeed, Lordship.
that will face in future if at all you come in the bar side.
Indeed, Lordship. As I already
Not that bar.
As I already submitted my argument, my Lord, we contend that the conviction should be overruled as the enough opportunity was not been given and the
That should close. That is basically in petition, a prayer is made any other orders.
Indeed.
That gives a right to the bench to pass any order whatever within the four
My
corners.
Lord, in that case,
That should not be submitted. That is my advice.
Indeed,
It's
Lord,
okay.
indeed.
This is your first time.
Indeed.
First time from you. So it's only that you just allow this appeal, and the case I may be given opportunity to appear before the trial court. There should be a retrial. Basically, your prayer is for retrial. Exactly.
Indeed, Lordship, with this we would say also should contain this is the case. So that such was gross violation of the right, the compensation should also be awarded to the accused. If in such any such order, then my lord can also accuse such compensation for right gross violation of rights of rights of the person. He has all the person of fundamental rights, and the state machinery, if knows that there is a right to be granted and violating one right for only for a reason that that right could be acquired for the preservation of another right, this is not the case. The state is there to preserve and secure the right, and they voluntarily violated that right.
But there is a famous phrase, my right to swing my arms culminates where other nose begins.
Indian lordship, that completely agree. There's another my lord also says justice Harit is justice Parit, my lord. That is
Therefore,
also
we gave you more time.
Indian.
Or what kind of other phrase?
Indian lordship has also the constitution.
Remand?
No, my lord, but we don't want to read that also, my lord. As the constitution says, that doubles your party concept. That is for the same offence, no one should be tried.
Yes, the judgment will be set aside and then the matter will go back.
Indian lordship, if this
What
conviction
is something else?
Indian lordship, but I was trying to say that if this conviction is not overruled, then in that case, if this overruled completely, an accused is given a fresh opportunity to prove himself before a court, and then after the charge.
No, then you are possibly not clear. I am asking you again.
Indian lordship.
If your appeal is held maintainable,
Indian lordship.
if your appeal is allowed,
Indian lordship.
and if the court feels that we have to pass an order, what kind of order you want? You want a remand? You want setting aside of this conviction and sentence, and you want a remand? So you will be reheard, you will be given opportunity before the trial court again, and you can defend yourself. So you discuss with your friends who are appearing with you, and you just tell me what kind of judgment you want from the court. We are convinced with your argument.
Your Lordship, may I answer to that
Yes.
question?
Come. Of course, subject to their argument.
Your Lordship, if the appeal is held maintainable by your discretions, we would like the conviction to be overruled. And as my co-counsel reiterated that the retrial will again cause him to go through everything. So we would most humbly submit for the conviction to be overruled, Your Lordship.
So you want to say that this conviction is bad
Indeed, Your Lordship.
and the judgment of the trial court should be set aside,
Indeed.
and that's it.
Indeed, Your
So you
Lordship.
have
Your argument should be
so
in that.
according to you, you have been able to make out a case that this conviction is bad on facts also, on law also.
Indeed.
Okay, this
It was an honor appearing before this
Thank
court, Your Lordship.
Yes, council seeks permission to close the hearing. The council seeks permission to submit the companion. Greetings to the honorable bench. This is the council number 1 with my co-counsel appearing on behalf of the respondents, the state of Jharkhand. The council seeks permission to address this bench collectively as your lordships. Oblige your lordship. Your lordship, I'll be dealing with issue number 1, 2 and 3 within the span of 22 minutes, whereas my co-counsel will be dealing with issue number 4 and 5 within the span of 20 minutes, and rest of the time is reserved for the rebuttal. Your lordship, as my learned co-counsel has mentioned some facts, I would just like to reiterate few facts which have been missed by the learned opposition counsel. Your lordship, paragraph number 13 of the fact sheet. Apologies, your lordship. Your lordship, paragraph number 10 of the fact sheet states that trusting his intentions, trusting the appellate's intentions and the commitment shown over time. Paragraph number 10 of the fact sheet. Trusting the appellate's intentions and a commitment shown over time, the prosecutrix agreed to enter into sexual relationship only on the belief and the promise that they would eventually get married. One more point I would like to reiterate here is that the appellant grew distant, avoiding every discussion about marriage and frequently made excuses to postpone and setting aside the wedding. This has been given in paragraph number 11. Also, one of the most important facts is paragraph number 25, which says that after following the requisite procedure under JNSS, the court declared him to be a proclaimed offender. And the most important point, your lordship has just asked this question to the learned opposition counsel. The point is, an appeal, this is paragraph number 26 of the Moot proposition, an appeal was preferred by the accused through his advocate. By the accused through his advocate certainly means that the advocate which has been produced is his advocate and not the advocate by the state. This
No, it was said that it was court's counsel.
Your lordship, paragraph number 26.
Appeal.
That question was with respect to
Appeal.
trial. Whether in the trial, whether during the trial, the appellant was represented through
By his
lawyer
counsel
or
or court's
amicus.
counsel.
Your lordship, that particular question has been dealt in paragraph number 25 and the facts are completely silent about it, whether the advocate...
So this shows that the prosecution has failed to prove the fact.
Indeed, your lordship.
Oh, you one thing I may correct you here. Just come back to paragraph 24 and 25.
Yes,
Paragraph
sir.
24 is, he was absconding and trial proceeded. When he was declared absconder and trial has proceeded, while he was declared an absconder, so therefore it is clear that he never appeared before the court. When he was not appearing before the court, how can you argue this? That his own lawyer was appearing before the court. So it is not clear, you can't say, it is very much clear that he was absconding, appellant was absconding, after he has been convicted and sentenced, he has preferred appeal. Yes, appeal is through his lawyer.
Indeed, your lordship. The fact I want to reiterate here is about fact number 26 in this particular appeal.
Yes.
In this particular, in front of this Honorable High Court, he has appeared through his advocate itself.
Yes.
But this fact is important while we consider that his advocate was not present in the Sessions Court, but is being present in the High Court. So,
Okay. That is okay, but that will not vitiate any proceeding, because if any accused is absconder,
indeed,
then
your,
definitely court has no option but to appoint a court's counsel, amicus, whatever you say.
indeed, your lordship. I was just reiterating the facts which are given in the fact sheet,
Yes.
which supports the argument. Your lordship, the first issue in hand is we have in hand is that whether this particular appeal in the present case is maintainable before this Honorable High Court or not. Your lordship, my argument will be a twofold argument. Coming to my first submission, it says that the judgment of the Sessions Court is not perversely rendered and substantial justice has been delivered to the prosecutrix. We can say that paragraph number 25, first line of the paragraph says that adequate procedure under the laws of JNSS has been followed. So, with this we can say that the appellate has approached this Honorable High Court regarding the conviction passed by the Sessions Court, and it is clearly mentioned in the factual matrix that the judgment was passed after following the prerequisite procedure. The trial was conducted in absentia and due procedure was followed. With the due procedure will be deliberated by me in the there is a bar on appeal by the proclaimed offender under the section 356 subsection 7 of BNSS or GNSS. Your Lordship, there is this case mentioned by the learned counsel which talks about trial in absentia. This case has been the case which has been mentioned by the opposition counsel. This case is this is a case of year 2022. But Your Lordship, as we know that if the laws
Yes,
Your Lordship, the case which has been mentioned, the Dhananjay Rai case, is a 2022 case which has been mentioned by the opposition learned counsel. But Your Lordships, as the laws of GNSS will apply in 2024, section 356 subsection 7, this subsection 7 clearly talks.
You mean to say that the judgment is prior to the new enactment?
The judgment was prior to the enactment of the new laws,
Yeah.
and subsection 7 clearly states that no appeal shall lie against the judgment under this section unless the proclaimed offender present himself before the court of appeal. It has been clearly mentioned in the facts that the proclaimed offender is not in front of this court for this particular appeal. So we can say that this writ, this particular appeal, apologies Lordship for the word, this particular appeal should not be maintainable in front of this Honorable High Court. Furthermore, they have
Then what should be alternative? Whether a person can be remediless,
Your
because
Lordship,
you will have to convince the court that if not appeal, whether revision,
Your
or no
Lordship,
person can be left remediless. That is the basic principle of this act.
Your Lordship, this is a criminal appeal, whereas they could have come in front of the Honorable High Court through any writ petition, where they could have challenged the constitutionality of this particular clause, or whether they could have challenged their conviction, whether this conviction is against their fundamental rights, or whether this conviction has not given them chance, to argue.
You mean to say a judgment of a trial court can be challenged in a writ petition?
No, Your Lordship. What I am trying to say is that if there is any opportunity for the appellant to be present in the court, then this could not be done under criminal appeal, which has been under section 415, which they are appearing in front of this court.
Read the provision for me.
Section 415.
Please.
Indeed, Your Lordships. Section 415 of BNSS, it says that any person convicted on a trial held by the High Court in its extraordinary original criminal jurisdiction may appeal to the Supreme Court. Any person convicted on a trial held by the Sessions Judge or an additional Sessions Judge, or a trial held by another court in which a sentence of imprisonment for more than 7 years has been passed against him or against any other person convicted at the same trial may appeal to the High Court. So this particular section they have taken into the consideration. Save as otherwise provided in subsection 2, any person convicted on a trial held by the magistrate of the first class or second class or sentenced under section 364, or in respect of whom an order has been made or sentence has been passed under section 401 by any magistrate. Then there is subsection 4, when an appeal has been filed against the sentence passed under section 64, 65, 66, 67, 68, 70 and 71 of the Bharatiya Nyaya Samhita, the appeal shall be disposed within a period of 6 months from the date of filing such appeal. Yes, Your Lordship.
So how you contended that the appellant should have filed a writ application against which order? Because there was a full-fledged order on merits and the appellant has been convicted for a particular period, life imprisonment perhaps. So if not appeal, then how writ will be maintained?
Your Lordship,
Dragging himself in different business.
Your Lordship, the writ may or may not be against the conviction, as this is a matter of appellant, but it may be for the rights which have been hampered because he has not been given equal opportunity to present his case.
Okay.
So,
So judgment of conviction remains, and he should approach the writ court for violation of his fundamental rights. What purpose shall be served? He is in jail.
indeed, Your Lordship, but the appellant has absconded and he and the appellant has absconded and he has
So you mean to say that, see, I'll tell you, if there had been a trial, there had been an investigation by the police, investigation was conducted hurriedly, it is their argument, but maybe after completion of investigation, charge sheet has been submitted, charge was framed, and trial proceeded. During course of trial, if he would have fled away, then matter is different. What is happening here according to us, that during the course of investigation itself, he was found absconding, he never appeared before the police and he never appeared before the trial court also. So if the trial court has proceeded and awarded this sentence to the appellant, only remedy is that if on the basis of or at the strength of this, because if he is filing appeal through his lawyer, although this fact is not very much clearly written, but fact remains that he is behind bar, then only he is approaching through a lawyer in appeal.
Your Lordship,
Actually, we should argue like this, that initially while he was absconding, but if at all the fact reveals somewhere that he was having knowledge, must be having knowledge, so initially he should have filed appeal, challenging the jurisdictional point before the High Court, but now he is having no other way but to challenge in appeal. Anyway, proceed.
Your Lordship, particularly in section, in the point number 24, paragraph number 24 of the Moot proposition, it has clearly mentioned that the appellant has failed to appear before the court, and after 2 warrants, he has been absconded from the court. So it has been clear that the appellant was neither in front of the sessions court, neither that he is in front of this appellate court. Neither police.
He is very much
He is in custody.
read it.
No, Your Lordship, he has been absconded.
Read that again. That provision you read.
Your Lordship, after for so it says that
My lord, see that provision. So point out that provision.
yes, Your Lordship,
Under which code you are?
the Bharatiya Nagrik Suraksha Samhita, section 356,
This goes slow.
procedural. Yes.
Which provision?
Your Lordship, section 356 is all about inquiry, trial, or judgment in absentia of a proclaimed offender. He has been declared as a proclaimed offender is an undisputed fact, as you mentioned in the factual matrix.
Okay, thank you.
The provision says that notwithstanding anything contained in the Samhita or any other law for the time being in force, when a person declared as a proclaimed offender, whether or not charged jointly, has absconded to evade the trial, and there is no immediate prospect of arresting him. I Your Honor, after 2 summons, after 2 warrants, he has not been arresting him. It shall be deemed to operate as a barrier of right of such person to be present and right in person. Right in person should be the word which we should consider, and the court shall, after recording reasons in writing, in interest of justice, proceed with the trial in like a manner like effect as if it was present on the proceeding. Yes, Your Lordship, but what this subsection 7 says, subsection 7 of this particular section says that no appeal to this section unless the proclaimed offender presents himself before the court of appeal.
Unless the proclaimed offender presents himself before the court of appeal, you should read it. Court of appeal. So you mean to say, law or judgment by any court of India or even High Court diluting this provision. So if we go by strict reading of a provision, it reads the state may see need to be physically present. Court of appeal. Yeah, court of appeal.
Your Lordship,
Yes, yes. The court of appeal. Court of appeal. Yes.
Your Lordship, but it has
But elaborate, you will have to elaborate this.
yes, Your Lordship, I'm trying.
Otherwise, it will go to the root of the case, root of the issue. And if you hold this, then the whole appeal shall be held to be non-material.
Yes, that's what we are contending, Your Lordships. That's it.
Focus on the or you are having one section of the subsection 7 of the subsection 7. So whether the surrender before the access to if we are not surrendered, you focus on this point, then we get from them what they are declaring material. Good thing is not right, certainly your for this particular reason, I would like to submit for this particular. No, yeah, flag your lordship. Your lordship, this is a particular case of Srikanth Upadhyay. It is the Supreme Court has stated that physical presence of an accused is mandatory in front of the court of law. So it has been clearly given and it has been marked. Your lordship. Your lordship, this is right to that. It won't take 23. It is not we making it of this appeal.
Your lordship, section 8.
If the person the person is
Just the
and is appearing to the council, then it is deemed that he is representing this physically. But it is not their part. It is still as order during in continuation of the trial. Then he will not get liberty of that. That is the fact.
Yes, Your Lordship. For this, we have to certainly understand
No,
what this particular section is that the person who has committed any previous crime, they should be present and they should not be absconded from the court of law.
So, what your fact says during the proceeding, whether he was behind bar or whether he was continuing absconding.
He was continuing absconding and he was represented by his lawyer.
You can only argue that is the technical part. Say, you are system. My only question. If he is assisted by counsel and he is behind bar or on bail, whatever, that is the only fact which is required. Okay, you can continue that. You are study or either of the two.
Yes, Your Lordship. For this particular thing, as given in paragraph number 24, after two consecutive warrants, the person is not before the court of law in the sessions court also. And after that, he is not in the sessions court and the matter was so the matter was trial absentia and after that the conviction took place. So conviction took place in April 2025. That means Your Lordship,
Yeah. The court stops hearing. Should you leave that one? Should you?
no, Your Lordship.
You read that Srikant Upadhyaya 9. Try to elaborate from there. On the point which you are raising and you are seeking to raise, there is no such judgment. But you can argue out from para 9 of this Savita Bai Govind Bhai Patel. Okay?
Yes.
Savita Bai Govind Bhai Patel has been quoted. It says, filing of an anticipatory bail application by the petitioner and accused through their advocate.
How I will you now here's the particular point. You should say on progression of law only by the court, then language is only with so appearance to you don't be able to approach that. So this is the case of the this should be the case of the prosecution. The prosecution has to that is a then after the
Your Lordship, what for this this Lordship particular to what we have to look for is the time. The conviction from the Sessions Court is being given in April 2024, whereas the report of this particular says that this particular appeal particularly regarding whether the application of substantive and procedural law in the given picture matters is correct. What we are contending with is according to the factual findings and the cases, the procedural law and the substantive law which was applied by the section is completely correct. By another point is whether this is a very important point is that whether the primary absentia adhere to the due process. Your Lordship, here you have to look for what is the date on which the first warrant has been executed or it has been issued. The time it is ambiguous that it is executed or issued, but the timing is around 1st January 2024. And when the trial has commenced, it is in April 2024. What my opposition counsel has argued that it, you have to very much progress of India. What then the time is given of you have to the learning admin council, what they have argued, that for the matter of medium offender, the time period of 30 days is considered. And for the matter under primary absentia, a period of 90 days has been given. By your Lordship, the proclaimed offender's definition and the proclaimed offender is given in the section 84 of BNSS, whereas primary absentia is being talked under section 356. The proclaimed offender section 356 clearly talks that the court shall not commence, it is the proviso in section 356. It stops that the court shall not commence the trial unless a period of 90 days has elapsed from the date of framing of charge. Now, what is the date?
he was given. It is fair because we have to be because we have to also consider what is the matter for the prosecutor. It is also equitable and it is not arbitrary in the law. If the prosecutors would continue to be absconded in front of the court of law for next few years also, then how can it serve the justice towards the prosecutors? To consider this also, we say that the trial in absentia adhere correctly to the due process of law and it is fair, just and equitable. That's all my submissions for today, Your Lordship. For the next two submissions, my co-counsel will take the task. It was my honor to be present here, Your Lordship.
Your Lordship, the Council seeks permission to approve the coding. The Council seeks permission to. Much obliged, Your Lordship.
Greetings to the Honorable Bench. The Council seeks permission to begin with this honorable. Much obliged, Your Lordship. Your Lordship, I will begin with fourth and fifth issue in the present case. Beginning with submissions of the fourth issue, the Council quickly submits that the company is guilty of fail under section 376 of GPC, and the Honorable Sessions Court has correctly charged him for the offense of rape. Your Lordship, here in this case, I believe that the present case is not a case of mere breach or promise to marry, but that essential sex. Rather, it is a case of false promise to marry and restricted consent. Your Lordship, in the present case, the appellant and prosecutors, both of them were in a relationship for about 5 to 6 months. And they were, and during that period, they were not into any kind of sexual relationship. At any time, before the appellant promised prosecutors to get married. Your Lordship, this shows that the prosecutors initially was hesitant to enter into any kind of sexual relationship. However, as soon as the appellant gave assurance and promised that he would marry the prosecutrix, the victim in the present case agreed for the same. That is entering.
You have to go with the they were in relationship. Jamie and Oliver maintained a strictly professional demeanor in public.
Yes, Your Lordship.
So it is not private. Public may they were maintaining the demeanor, consciously avoiding any display of affection. So this line, you just
Yes, Your Lordship. In my subsequent submissions, I have covered both this.
Yes,
topic. So,
how you will say that the word incorporated in paragraph 7 of your factual, they were very much conscious and strictly professional demeanor in public, which strictly goes to say reverse. That in private they were having relationship.
Your Lordship, if you could kindly refer
Yes,
to
yes.
paragraph number 10 of the
Okay.
factual matrix. The second line, from the second line, it reads that trusting his intentions and the commitment shown over time, Oliver agreed, that is the prosecutrix in the present case, agreed to enter into a sexual relationship.
See, you are having your prosecution. In each and every step, you have to prove the case.
Yes, Your Lordship.
That is the thing. Your partner has already drawn attention of this court towards point number 10. So by virtue of this, you are giving reference that the first time the physical interaction came was on 1st of 23.
And then the another thing starts with the suspicious behavior. So the calculation should be entirely different. or the law should deal with this chain of events in reality, really connecting whatever happened before that suspicion happened. Before that suspicion, everything was alright.
Yes, Your Lordship. What we are trying to contain here is that all these, from all these actual circumstances and the behavior of the appellant previously and subsequently, when we made the promise, from all these actual circumstances of the case, what we can gather is that he had no intention of marrying the prosecutor since the very beginning, and that he had made a false promise of marriage with the prosecutor. And this has also been covered in my subsequent submissions. Your Lordship, this clearly shows that the prosecutor initially was hesitant to enter into any kind of sexual relationship. However, it talks about the consent known to be given in the misconception of man. Here or misconception. If I may kindly,
Yes.
the consent is not such a consent as is intended by any section of this code. If the consent is
So
given
this is a disputed question of fact because this was an ex parte hearing.
Yes, Your Lordship. And what we are trying to contend here is that this is not a case of mere breach of promise to marry. Rather,
It's okay, but it is a disputed question of fact. Whether it was, because it has not been proved when the accused is present on the dock.
yes, Your Lordship.
It has been proved by the the clean accusation. But at least the accused must get a chance or you can.
Your Lordship, my counsel also argued in the first instance that enough opportunity was given.
Say that I would like to speak for the amount of time and we have to see.
And thus in the best interest of justice,
Yes.
I like to proceed.
Thank you. I wish to proceed at this procedure upon in the notice.
And Your
For
Lordship,
few dates, they are some that it is not in the
and thus Your Lordship, through my submissions, I will prove that this present case is
some just an extent of that. Whether it will not be this, they will be fifteen and one. By few persons, we never appeared before the charity. But then we appeared before the for two representatives. Whether he does not respond to what he told him not to. We only
Your Lordship,
next week open.
yes, Your Lordship, regarding this.
Even we are not going on that issue that now when the physical event started, nothing we are not only this time.
Your Lordship, I would like to mention that when we pause it, your judges and also I would like to mention in the present, I would like to mention in the present is that,
Law of this country.
but
The song are very mature is not simply very of this country.
yes, Your Lordship, I would like to mention here that each and every procedure requirement has been fulfilled in the and thus, interest of both parties have been concerned by giving or by regulating the judgment. Thus, we are considering the rights and duties of the accused and the rights of the prosecutor. Prosecution should also
But in this country also there are so many things like
Your
hospitals are provisional like this new act also.